Well, good afternoon. Thank you for joining us for the second of our post-budget webinars. And today we're going to be focusing on personal wealth in particular and how the changes that have been announced to personal taxation could impact you. I'm Zoe Davis. I'm a personal tax partner, and I'm joined today by James Robinson, who's a financial planning director, and Paul Barham, who's a fellow personal tax partner. So before we begin, a little bit of housekeeping. Please use the question and answer boxes to submit any questions that you have for James, for Paul, or for I. We will address these towards the end of the session, and the session will be recorded and a copy will be sent to you via email. If you've joined us for previous sessions that we've had immediately after the budget, we didn't have time for questions during those sessions because there was so much to discuss and update you on. So these sessions have predominantly been designed to ensure we do have the space and the time to answer any questions that you've got. So we have had a few through already, and thank you for submitting those, and we will make sure we start with those questions. But if you have any more that spring to mind as we are talking, please use the Q&A box and we'll make sure we get to those after we've done our short recap. So without any further ado, I'm going to start with today's agenda. So the personal tax changes we're going to cover will be pensions, inheritance tax, capital gains tax, non-domiciled changes, and a short note on VAT on private school fees, albeit we haven't got a VAT specialist with us, so that will be a short overview. No tricky questions on VAT, please. On a serious note, if there's any particular questions that aren't quite in our specialist area, we can always follow up separately if needed. So I think we should kick off then and go straight to pensions. James, will you take us away, please?
Absolutely. I think probably most people on the webinar are already aware that there's been some big announcements in the change of pensions, as there seems to be some kind of big announcement every year or two at this rate. The big change really being announced that pensions are going to be subject to inheritance tax and be part of the estate from April 2027 onwards. So the current position is that pensions are not part of people's estate in most circumstances. There are some times where it can still be included, but from April 2027 that they're going to be included thereafter. So a big change coming up in terms of death benefits and inheritability of pension. But where we did see quite a lot of rumour and worry and headlines about potential other pension changes, that was actually the only change that was announced. So what hasn't changed is the rate of pension tax relief and the amount that people can pay in on an annual basis, known as the annual allowance. There's been no reintroduction of the lifetime allowance, and Rachel Reeves, ahead of the budget, did actually say as well that she's not intending on reintroducing it anyway. And I think what was most talked about and most worried about for a lot of people was that the lump sum allowances remain unchanged. So the amount of tax-free cash you can take from your pension is still the same as it was before. Now, there's still lifetime limits in place, but it's the same as it once was. So it's really the death benefit efficiency of pensions that has changed, and it's a U-turn on the previous position. A lot of people took the view of, well, if it's outside of my estate, my pension, well, I won't actually use that myself. I'll use it as a wealth planning tool for passing on to next generations. We're now in an environment where if someone dies after the age of 75, they can have both inheritance tax and income tax payable on their pension assets, which, if your beneficiary is a 45% income tax rate payer, can generate a total tax of 67% on pension death benefits, possibly even higher if the value of the pension starts to lose you your residence nil rate band as well. So what this will mean for a lot of people is that if they haven't already, that they should be reviewing what their drawdown strategies are going to be in light of the upcoming changes. Just remember, this change hasn't come into effect yet, and it's still yet to go through legislation and be made law. So this is not a run out into the streets, rip all the money out of your pension because it's going to be taxed a lot. What it will require, though, is people already in or coming up to retirement should be reviewing how it is they use their pension in comparison to other assets, and whether they use their pension as a retirement fund and then can do some inheritance tax planning with other assets, which will be a novel experience for a lot of us these days. As Zoe, you said, there's plenty of time for Q&A, so this is a very short summary of the changes. There is a lot to cover potentially still, but if anyone does have any questions on this, please ask and we can come back to it later.
Thank you, James. And I must say, of all the questions that were pre-submitted to us, the majority of them surround James's topic. It's clearly something that is of real interest to those attending. So any other questions, please send them through and we will get to them at the end. And be prepared, James, lots of questions coming your way. I'll touch now, if we move on, I will talk about inheritance tax and give you a reminder of the changes here and what they need. So we have our current thresholds that are frozen until 5th of April 2030. So quite frankly, what it means is we need to think about those inflationary increases that might be happening within an estate, and that nil rate band is not increasing with them. So something to be mindful of, and perhaps reminds you to refresh plans that you had in place. James has talked about pensions, so I'm not going to touch on that. I'm going to move straight on to what I think is the biggest piece of news that came out in the inheritance tax arena. For business owners or for those in farming and similar industries. So we previously have had an unlimited relief available from inheritance tax, agricultural property relief and business property relief, or business relief. And this changes from 6th of April 26. And from this date, we have a £1 million cap that covers both agricultural property relief and business property relief, and it's shared between the two. After that, our relief is restricted to 50%. So effectively, it's a 50% of what would otherwise be a 40% IHT charge. So for ease, you can think about it as effectively a 20% tax charge, inheritance tax charge on value above £1 million. This is a really significant change, and has been a lot has been covered in the news around how this will impact farmers, but also business owners and their planning. What we would encourage everybody to be doing is thinking about their individual planning and how this may change as a result of these numbers. The starting point here would be working out what your starting point is actually. So understanding the valuations that exist for anything that qualified for agricultural property relief or for business property relief. So any shares in businesses or farmland, anything like that. Starting point is understand the actual value that we have. To just a slightly techie point, but it's probably because I'm talking about values, I think it's worth talking about. Agricultural property relief will be for the agricultural value, whereas what we are looking at when we are subject to inheritance tax is the overall value. So what we are looking at when I'm saying find out your starting position, it's the overall value that we want to understand that exists. So the real value, if I can put it that way, then working out what reliefs you would get. So agricultural property relief on the agricultural value of anything that might qualify, and anything that might qualify for business property relief. And all of that is then capped, that relief, at 1 million for 100%, and then 50% for anything over and above that. So starting point is working out your valuations and what your exposure might be, and then start to consider whether your succession plans or whether your previous plans for inheritance tax are still fit for purpose. To give you an illustration here, we've used an example of where an individual passes away holding £15 million of qualifying business assets and £5 million of qualifying agricultural land. Until 6th of April 26, we have zero inheritance tax to pay there. And after 6th of April 26, that changes to £3.8 million, which is a significant difference. And as a result, one of the things to be thinking about is how that would be funded. Even if no planning is undertaken, no changes are taken, we need to think about how that would physically be funded in due course, which links back quite nicely to James and financial planning considerations. As a next step, one of the things to be thinking about would be whether any lifetime gifts might be appropriate in the circumstances that you're in, and if so, how they would work, who to, how, timing, and what reliefs you would be intending to claim as part of that planning. There's a lot to consider here, and I've spoken to a lot of clients since all this happened, and there's different considerations for different families, and what I've learned, if I didn't know it before, part of the last few weeks discussing this, is every different family is going to need a different solution and a different answer. But the best thing you can do is start those conversations early, to be thinking about what might need to happen prior to 6th of April 26. So a really big change here, and definitely time to dust off your plans and think about them. I think we'll move on to capital gains tax now, slightly less morbid than inheritance tax, and a bit of, I'm going to say, good news here, because there were changes to capital gains tax rates as we expected, but they were not as bad as we expected or as they could have been. And so in a way, this is positive news for those that were thinking about transacting or realizing assets through a sale or a disposal in some way, shape, or form. So refresher of the changes, we've had our CGT rates from 30th of October 24. So it's already happened. It happened on budget day. They have been uplifted. So we did have a 10% rate as our lower rate of capital gains tax, and that's been adjusted to 18% from 30th of October 24. Our higher rate was 20% up to 29th of October 24, and that's changes and increases up to 24% from 30th of October 24. Our lower rate on residential property is unchanged at 18%, and our higher rate on residential property is unchanged at 24%. And in fact, what we've got is an alignment to those rates of tax. The other change was the business asset disposal relief, investor relief, where we, and this one you have got some time on, so please pay attention to this one. We did have a rate of 10% of tax where you qualified. The reduced rate of tax that you would pay up to £1 million was 10%. From 6th of April, that 10% increases to 14%, but we've got a bit of time between 30th of April, between now, we've moved on, haven't we? Between now and the 6th of April 25. So if there were any assets that you had that could qualify for business asset disposal relief, if you disposed of them prior to 6th of April 25, you would still be paying that 10% rate instead of the 14% rate that is coming in from 6th of April 25. So just want to consider and understand whether there's anything for you to do there, and whether it's worth thinking about any disposals that you might have been considering doing in the short term in any event. That rate increases again from 6th of April 26, and it then goes up to 18% and aligns with our lower rate for residential property and our lower rate full stop for capital gains tax. So there is some time if you have any assets that qualify for business asset disposal relief to consider disposing of them prior to 6th of April 25 or from 6th of April 26 to secure either the 10% rate or the 14% rate. Carried interest has or will be changed. So we currently have a 28% rate that's charged on that, and that will be going up to 32% from 6th of April 25. And after that, we're expecting it to align with the income tax regime, but further details will be coming on that in due course. So this is just going to go up, I think, is the message here. So in a way, I think the capital gains tax changes are probably going to mean those that were, quite frankly, holding off transacting because they couldn't transact prior to budget day. This is likely to be accelerating now discussions and decisions on transacting. So they didn't go up as high as expected. Could they go up further in due course? Who knows? But I think this should prompt you to be considering whether it is appropriate now to make any of those disposals. Lots of different planning points that you can consider if you are suffering with any CGT exposure. So just a few things that we've mentioned previously, but it doesn't hurt to refresh them, I think. You can always consider an EIS investment or a CDIS investment to defer or remove any capital gains tax that might be arising. Consider spousal exemptions. You can, or spouse or civil partners, you can transfer between you and not have that CGT charge. So it's worth working out how things might sit. To get a little bit more complicated, if you've got a company, you can consider having a holding company on top of the company to benefit from, if you were going to dispose of your company in due course, benefit from substantial shareholding exemption, where the company wouldn't pay any capital gains tax effectively on that disposal in due course. And then you can consider your personal planning with how you might extract those proceeds or do something with them in due course. So definitely something to consider there. And we would always say where there's a single company that exists, consider whether you should have more than one to have a holding company to take advantage of substantial shareholding exemption. I think that really comes to the fore now for people to consider their planning. You can always consider holdover or gift relief where we've got any qualifying assets, so business related assets, and also consider any lifetime gifts effectively for succession planning. So linking back to what we just talked about with the inheritance tax exposure, if we are gifting away assets, we can always be thinking about how we can mitigate the CGT on those by using the reliefs that are available to us there. So they can help us as well from a capital gains tax perspective. And the final point I would make is for any non-trade assets, it's effectively a harder decision to make, or some more consideration to be given, where we've got effectively a 20% inheritance tax charge, where we fall into the restriction on the value where we get the relief. But we've got 24% of a capital gains tax charge, perhaps, on the gain on an asset. So there is it's a much closer decision now to be thinking about, and really a case by case basis. And working those numbers is a really good idea in order to feel informed and make the right decision for you. Okay, so I think that's enough about capital gains tax for now, and refreshing your minds on what's happened there. Paul, can we come to you to talk us through everything there is to know on non-domiciled individuals and changes?
Everything there is to know, might be pushing
We haven't got the time, have we?
We have got a webinar coming up on Wednesday if anybody wants to spend a whole hour talking about the non-dom changes. So I think it's worth putting into context, first of all, what domicile is compared to residency, because up until now, but until the 5th of April, we run our tax system in the UK based on whether you are tax resident, and we run the tax system based on whether you are tax domiciled. Now, domicile is a really messy term for tax purposes to try and explain. In its simplest form, it is where you are come from, where you are attached to, where you belong. Now, somebody who is born in the UK to UK parents typically has a UK domicile from the outset. Somebody who has come into the UK will, if they don't establish an actual domicile, will establish deemed domicile after being here for 15 years. There are winners and losers to these non-dom changes, and I will explain why when we come on to the IHT position, because detaching domicile from the UK tax legislation and replacing it with a residency-based test means that if you were UK domiciled and you had a domicile of origin, you would struggle to create a separation from the UK that was strong enough to detach yourself from the UK domicile that you started off with. With residency, you can count up the number of days you're in the UK and make sure you're under the relevant threshold for long enough, and you can become a long-term non-resident. So those people that are leaving the UK that were born here, I think, can access some of a better regime than maybe those that have come to the UK and are maybe settling for a little bit longer. But domicile is on its way out. And it is going to be replaced by a simple, how many years have you been resident under the UK statutory residence test? And if from the 6th of April 2025, if you've not been UK resident for 4 years under the statutory residence test, and I keep saying statutory residence test because if you are not UK resident because you're making a claim under the treaty, or you're able to split a year, that still counts as a year of residence under the statutory residence test. But if you've not been here for 4 years, then the regime that we have currently of the remittance basis, where you cannot pay tax on your non-UK income and gains if you don't bring it to the UK, is being replaced by a simple 4-year exemption. So whether you keep non-UK income or gains outside of the UK, it will automatically not be taxable for those first 4 years. It's worth noting that it's not the first 4 years to you. You start your 4-year clock when you first become UK resident, and it ends 4 years later, 4 tax years later. If you disappear out of the UK for a couple of years, you don't bank 2 years to use when you come back. So it is the first 4 years. Welcome to the UK bonus. Of course, there are people who are already in the UK and already use the remittance basis. So there are some provisions to accommodate and adjust for this switch from domicile and remittance to residency, the residency-based system. One of them is the TRF, or Temporary Repatriation Facility. This simply allows people who have claimed the remittance basis on income and gains up to the 6th of April 25, have not paid tax on it, to decide that they would designate that income and pay tax on it. Now, it's worth noting that it is a designation, so you don't actually have to move money into the UK. You can designate funds that are wrapped up in a non-UK trust. So there is a lot of scope to access the TRF if you have claimed the remittance basis previously. And it's at a really much lower rate of tax. So if income tax, our top rate of income tax is 45%. For the tax year that will start on the 6th of April and the following year, so right up until the 5th of April 27, that designated income or gains under the TRF will be just 12%. If you decide to wait until the 3rd year, so from the 6th of April 27 to the 5th of April 28, that TRF rate is going up to 15%. So it may be that somebody waits until 27, 28, certainly in some circumstances I can maybe think of, but on the whole, you would expect most people to do that claim in those next 2 years. If you're holding an asset rather than income or proceeds from disposals, then they can be rebased to the April 2017 value. So this means that if you had an asset that was held, you maybe acquired it in 2010, it went up in value to April 2017 by 50% and has gone up by another 20% since. When you eventually sell that asset, if you're not subject to FIG, you would then pay capital gains tax, but only on the gain on that 20%, the difference between that April 2017 value and when you actually sell it. For visitors that have come to work in the UK, we had an overseas workday relief, so you only paid tax for your days that you were spent working and the salary that was attributed to that in the UK for 3 years. That's been extended to 4. Previously, you had to keep that salary outside of the UK. It had to be paid to an overseas bank account. That test is being withdrawn, but there is a cap to the relief, so it's the lower of 30% of earnings, or £300,000. So income tax, there is a benefit if you are coming to the UK, if you are new, if you've been in the UK just for a short period, if you've been able to access the remittance basis. There's a number of provisions that can provide quite a good trade-off for the switch in systems, but there's probably a little bit of thinking to do around when to nominate, whether to crystallize income before the 5th of April, or whether if you haven't claimed the remittance basis, whether to make that claim before the 5th of April. So winners and losers, probably on the whole losers in the sense of those that are already here. Winners perhaps if you are coming to the UK, or if somebody is UK domiciled but been out of the UK for 10 years already, they could come back and now qualify for the 4-year FIG, which they would not have done if they'd have come back after being 10 years non-resident under the domicile remittance regimes. Inheritance tax and trusts. We've spoken quite a bit about inheritance tax already this afternoon, but you would be somebody who is not domiciled but resident for 15 out of 20 years, subject to inheritance tax on your worldwide estate. The new rules have shortened that period down to 10 years. However, it is a residency-based system now. So if you have been non-resident for 10 years, but you would have been UK domiciled, you would equally have this same access to limitation of inheritance tax. So it's just on UK assets. So whilst those coming to the UK start to pay UK inheritance tax much more quickly, those who are from the UK that are spent a 10-year period out of the UK may find there is a period when their estate is not subject to IHT on a worldwide basis. those that were leaving, the tail used to be 4 years. So if you were for the first 4 years after you left, you still would be exposed to UK inheritance tax on your worldwide assets. That is increasing to 10. So the 15 is going down. The tail, as we call it, is going from 4 to 10. That does shift if you are here for 12, 13, 14 years. That is slightly shorter, but essentially you have a 10-year wait to escape the UK's IHT net now. Now, many non-doms would have organised their affairs in such a way that even if they were here for more than 15 years, they would use offshore trusts, non-UK trusts, to essentially manage their UK IHT exposure. They have been subject to a lot of anti-avoidance rules, some of which will continue from the 6th of April. But some of the protections, the protected trust status that you may have heard about, that is going so that if you have set up a trust for your benefit, but it's offshore and you were not domiciled, then you might find the protections that kept the trust's income and gains out of taxation will be lost from the 6th of April 25. And offshore trusts were a really smart way of essentially keeping non-UK assets outside of the UK IHT net, even if you had been a non-domiciled individual who had been resident for at least 15 years. That is going. The IHT exemption will apply if you are within that 10-year window of only your UK assets being subject to IHT. But if you have been here for more than 10 years and you are a long-term resident, your trust will also be subject to IHT. And there were some anti-avoidance rules that we've had in since the 1980s around gifts with reservation of benefit, that there was always a get out for protected trusts. That will go too from the 6th of April. It does mean that there is a potential for assets in an offshore trust to be subject to inheritance tax within the trust and deemed to be in the settlor's estate for IHT purposes. So there is, with the gift reservation rules kicking back in, a potential for a double charge to inheritance tax. Now, trusts don't usually pay inheritance tax at anywhere near 40%. They are usually max of 6% every 10 years. But nonetheless, that opportunity, that shift from essentially an IHT-free environment within an offshore trust to IHT at even 4, 5, 6%, plus a potential to drag the assets back into the settlor's estate, is quite a sizable shift in tax liability. So we spoke earlier about APR and BR and how to fund that tax. If there's not a way of unraveling and it's not sensible to unravel some of those structures, it is at least worth having a refresh on how is that tax going to be funded, because it was a 0, it could be 45, 46%. So there are winners and losers, probably more losers in terms of who this legislation is aimed at. But certainly if someone is thinking about leaving the UK for a long period of time, maybe there's some opportunity to revisit some planning there as well.
Excellent. Thank you very much, Paul. Okay, we're going to move on to our final smaller topics of VAT and stamp duty land tax, and then we're going to come to your questions. And we've had already some through whilst we've been talking, so thank you for those. And we'll come to those shortly. So VAT. So from 1st of January 2025, fees that are paid on private education and boarding services, well, VAT is going to be charged. So we've got some. Okay, I'm going to use Paul's phrase here. It's brilliant, winners and losers. So the losers here are those that have tried to get in early. You know, so we knew this change was coming, suspected this change was coming. Any prepayments that have been made, unfortunately, they're going to be caught by anti-forestalling. So what that means is that anything that relates to term starting on or after 1st of January 25, even if it's been paid earlier, are going to be subject to VAT, I'm afraid. However, we have got an easement where the government have stated that local authorities and devolved governments that fund children with special needs will be compensated for the additional VAT, provided those special educational needs cannot be accommodated outside of private schools. So I think mainly losers perhaps on this scenario for people where VAT is going to be charged going forward. Stamp duty land tax, so this affects England and Northern Ireland, and it's effective from 31st of October 24. The rate is going to be increased from 3 to 5% on the higher rate for additional dwellings. Wales and Scotland do have their own systems, so land and buildings transaction tax and land transaction tax. So that's it. That's all I wanted to cover on VAT and SDLT. What we will now do is move to the questions that have been sent through prior and on the Q&A. And if you have any more questions, please send them through whilst we're speaking, and we'll make sure we get to those for you. So first one, and we probably can get rid of the slides now, I suspect, and you can. I mean, we can probably zoom in on James, because James, we know we're coming to you. There's lots of questions.
Oh, I'm sorry, everybody. I'm sorry.
The first one, James, somebody has written in saying they're planning to retire, and in May 2025, are they likely to be taxed on their lump sum?
So, the immediate answer is probably not. And the reason it's probably, it depends in what context you're referring to the lump sum. So most people will be referring to tax-free cash payable from pensions. And so at least the tax-free allowances have remained as they once were. So under normal rules, people can have £268,275 of tax-free cash over their lifetime. I really do wish that they'd made that a round number, but I'm stuck with saying that for the next few years, it seems. That those that had any kind of lifetime allowance protections would also be able to take a higher amount of tax-free cash based on what that lifetime allowance protection enabled them to take as well. So in talking about tax-free cash, then that should still be tax-free as expected before the budget as well. Just bear in mind that it's possible to, in some circumstances, take lump sums from defined contribution pensions, which are a mix of tax-free cash and income, or indeed are solely income as well. So this is why I say in most circumstances, when people talk about lump sums, it's a tax-free element, but just because there's an ability to take taxable income lump sums, that's why I mention it. Also, of course, lump sums on death do have some limits of how much can be paid tax-free, but I imagine from seeing other questions, we'll come on to that in a second.
Thank you very much, James, and we'll keep you going. Next question for you. Does the budget change the tax position of undrawn SIP benefits post age 75?
Yes and no, to allow my enigmatic way of answering questions still. So in terms of, does it change the taxation of them? Yes, it does, because it now applies inheritance tax to them as well. Unfortunately, and we'll stick with the theme of winners and losers, that the losers are the people that, well, there would still be income tax payable after age 75 on lump sum death benefits. That's still the case, as well as inheritance tax. So you've gone from an environment where you're expecting your beneficiaries to pay income tax on what it is they draw. Now you're expecting them to pay both IHT and income tax. So while the rules as before haven't changed, they've just had this extra one tacked on top now as well. At least if death were to be under age 75, pension funds can still be passed on free of income tax, and how much tax might be payable depends on the options offered under your pension scheme. So basically, it's, if you haven't already checked, it's really worthwhile reviewing what the death benefit options are from your pensions, and just that they allow you to be able to pass on the fund to definitely make sure it's tax-free, rather than just having a limit of £1,073,100 as a lump sum. Thank you again for round numbers in pension legislation. So no changes to what once in place, other than adding on IHT on top, basically.
Should we give him a break and pick someone else? Pick Paul and I for a question. Paul, one non-pension related question that perhaps you can start on. What would be the simple tax mitigation steps people can action now, which is quite broad? And the second part of that question is, has there been any impact on FIC, so Family Investment Company, tax planning strategies, and can you summarise?
Okay, so I think the simple tax mitigation steps very much depend on the makeup of somebody's assets and income streams, family, business interests, all of those different things. I mean, if I whiz through the main changes, I think business owners need to think carefully about their structure. They need to think carefully about how they might exit, or whether there is a family succession or a management succession of some kind, because the changes to capital gains tax, the changes to business relief, maybe agricultural property relief, if that is an agricultural business, all highlight a difference in the amount of tax that was going to be paid pre-budget. And on the whole, that is a potential to be a higher number, so a loser situation rather than a winner situation. So I think it's really important to just take a fresh look at everything, because it's very easy to assume that I took some advice, I restructured my business, my assets, my will in a way that meant that I was being efficient from a tax perspective. And it is quite possible there is a less than optimal plan as a consequence of the budget last month. Obviously, if you are someone with an international presence, certainly if you are somebody who was not domiciled or is not domiciled, and if you are somebody who's thinking about coming or leaving the UK, then absolutely the mitigation step is to get some advice. And I say that in the simplest sense that our existing anti-avoidance legislation, our existing legislation around the remittance basis and domicile was incredibly complex. The new regime is actually designed to simplify that. And I think it does do, I mean, often legislation changes to simplify things and it does the exact opposite. But I think it is simplifying the legislation. The reason why I think you should get some planning is because of all of those transitional provisions, because you may find that you want to crystallize income overseas now. You might find you want to crystallize income after the 6th of April because you're within the FIG regime. You may want to crystallize income but not bring it in. You may want to bring in some money now. There's a lot of different challenges that people are facing to come out with a tax mitigation one size fits all answer. The second part of the question around family investment companies and has there been any impact? I mean, there hasn't really, because most family investment companies do as they say and hold investments which typically don't qualify for business relief or agricultural property relief. They may do, and it may be worth that they're impacted. Corporation tax hasn't changed to any large degree for family investment companies, so there isn't a huge impact for the company itself. If somebody wanted to give away an interest in an investment company or change shareholder rights or anything like that, the only real change would be whether the rate is the same. If that's something that's subject to capital gains tax, then it's probably gone up to 24%. Inheritance tax can sometimes be triggered when somebody is playing around with shareholder rights in investment companies. The rate is still the same. As I say, it's the reliefs that have changed. So I don't think there has been any huge impact to family investment companies, but I would suggest answering the first part of that question is a tricky one, depending on what pattern of assets and income streams somebody has.
Excellent. Thank you very much, Paul. Okay, James, you've had your break. Next one for you. And I know you've touched on this, but I think it might be helpful to go over again. So the question is, doesn't the inclusion of pensions in estates for IHT mean double taxation, i.e. on death and again when the beneficiary draws the income therefrom?
Yes, it does. Okay, to expand further than a shortcut, yes, that what this has created quite a lot of quite fairly. People aren't really happy with this as a change, as they don't really like the idea that tax is now going to be payable twice for both income tax and inheritance tax. And on face value, yes, that feels very harsh and very punitive that you could have a 67% tax charge. And I'm not saying this from a perspective of trying to justify it, but just putting this in the context of the widest scheme of different assets. That if you think about the fact that you've at least had income tax relief when going into the pension, and that if you've had tax relief at your marginal rate, well, if you're the same marginal rate of taxpayer as your beneficiaries would have been anyway, then it just means that pensions are neutral with other things, like ISAs, for example, that you still net down to a similar amount that gets inherited by the beneficiaries after all the inheritance tax and income tax charge have been factored to, but there's just a different way of getting to that same number. It's why I'm really careful to make clear to people that it doesn't mean pensions are therefore rubbish and therefore shouldn't be used. It's just that they're using them efficiently will be different, and it's just making sure you're still getting the most out of them, I think, is the major change. So it is a double taxation. Yes, it's not as good as it once was, but it doesn't mean it's necessarily bad, I think, is the other point to say.
Thank you very much, James. I'm going to keep you going, if that's all right, James. So don't go on to mute yet. Another question for you. My understanding is that the change in rules only applies to DC pensions, no imputed value of any DB scheme.
Yeah, that by the nature of how defined contribution pensions and defined benefit pensions, so DC and DB, so DC is defined contributions, the pot of money pensions, DB a defined benefit, which is a promise of income from a certain age. Defined benefit pensions most of the time end on death or end on the death of the surviving spouse, so there isn't inherent value once those pensions are in payment to assign for RHT purposes. So it's a de facto basically there's no inheritance tax to pay because there's no value to pass on. So therefore it is really defined contribution pensions. Now, some defined benefit pensions offer lump sums payable on death, and those were usually part of the estate for RHT purposes anyway. So it's not a change, it's just understanding that, okay, if you are planning on relying on a guarantee period or something like that from a defined benefit pension, then, well, it could have been subject to inheritance tax anyway. I think something that's worthwhile mentioning, because it's if you follow the thought process through, then it does make sense, but it's also worth remembering that on first death between spouses or civil partners, then the assets can still pass free of inheritance tax. So it's only once you're passing that asset down to future generations, usually, that you're thinking of this inheritance tax charge to apply. So if you're thinking of your pension in light of a retirement fund for both you and your partner, or I should say spouse rather than partner or civil partner, because IHT could apply if you're not married or in a civil partnership, then it can still be a really efficient retirement fund for the both of you, but it's when it passes on to that next stage. While I'm on a roll, Zoe, can I add a thought that came to mind while you were talking earlier as well, if I may?
Of course.
That one of the other things, so business owners have been more affected by a lot of these changes through change in business relief and also through RHT changes. But the thing I want to mention, especially on pensions for business owners, is that they're much more likely to own a commercial property as part of their pension, as part of running their business a lot of the time. And so what you might have found that people would have bought a commercial property, then had their business rented off their pension as another way of funding their pension, saving cost to the family overall. That where IHT is going to become payable under the way it's been announced is that the pension fund is also going to be liable for some of this IHT as well. So it's going to create potentially some liquidity issues for anyone with a property within a pension. And typically those are usually business owners. So if you have a property within your pension scheme and that forms a large part of your pension, then pay very close attention to this consultation period that we're going through and what comes out of that, to say, well, how would then liquidity be created within a pension if there are no other funds other than a property? Are you going to need to build up a fund, for example, to pay for the IHT within a pension, or might some borrowing be needed in some way? But it's just something I thought I'd mention, Zoe.
Excellent. Thank you, James. Final question then. And Paul, you can take this one if you like, or as you've already answered one, you can have a break. I'll let you hear it and then you can decide. So the question is, do donations class as expenditure for purposes of gifts out of income calculations?
I will answer it. I'll play, not pass. I think I assume we're talking about a charitable donation, and and a charitable donation, certainly to a UK charity or UK registered charity, is usually immediately exempt. And that's during lifetime. If you make enough of them and 10% of the net estate on death is being left to charity, then actually not only is that exempt, but you can get a reduced rate of inheritance tax to 36%. If it is not, and I know in various regimes in various countries, donations to people are expressed in that way, and there's a regime to tax them accordingly or to relieve them accordingly, then that's when the gift out of surplus income rules can come in, and they could be immediately exempt. And just in I guess from the way that question was written, that somebody is well aware of the regular gifting out of surplus income rules. But just in case somebody isn't, if you have surplus income and you make a regular gift of that surplus income, then that is immediately exempt. That gift is immediately exempt from inheritance tax. You don't have to wait 7 years for it to fall out of potential charge. It is always worth noting, and I cannot stress this highly enough, you need a regular pattern, which is not entirely defined, but you need to make sure there's a regular pattern for that regime to apply. And you need to be confident that it is out of surplus income. Surplus income is very broadly income that is surplus to somebody's need to maintain the lifestyle to which they have become accustomed. You cannot substitute income for capital and live off your capital and give away all your income and fall within it. You can only fall within this regime if your total income net of tax is sufficient to meet your expenditure, whether you use your income to pay for it or whether you use capital to pay for it. So it depends whether it's a charitable donation or not, is my very short answer.
That's great, thank you.
Onto your,
of course, go for it, James.
Paul, the surplus income gifting rules is one that has come up a lot more recently as well with the pension changes. I want to keep talking about them. That because there is also the option of, well, if you've got a pension fund and you can generate a regular income from your pension fund and it's surplus to your requirements, could you then gift that away IHT free? So if your beneficiaries were going to be paying income tax, could you pay the same rate of income tax, but then just pass on the pension free of IHT at that stage? So again, are some of the things that could and should be considered over the next few years. What Paul mentioned there about the capital versus income, and you can't live off your capital elsewhere than generate the income to give that away. That's already a conversation I think I've had sort of 5 or 10 times over the last month that has been. So really worthwhile making sure you're being careful if you're going to be using those gifts out of income rules to get the proper advice to make sure that it's all going to be effective.
Absolutely. Thank you, James. Thank you, Paul, for sharing thoughts and the answers to those questions, and thank you to all of our attendees who have joined us today. If you would like any further details, Paul,
sorry, we've just had another question pop up.
Thank goodness Paul's on the ball. Hadn't seen it.
I think it's for James.
Of course, maybe it's for James. They're always for James. You, so. So the question we've had, thank you, Paul, is it worth taking out insurance to cover an IHT liability? James, do you want to?
Yeah, sure. I can't give a curt yes or no to this one. That depends on circumstances, etc., etc., etc. So all those disclaimers out of the way. That insurance is going to, I expect, is going to be a much larger part of a lot of people's inheritance tax planning already. And Zoe, you and I have already been speaking to a few business owners of our clients of where you've got a business where there is now a potentially huge lump sum tax charge on death of a shareholder, but there isn't a viable way to immediately create that value. That insurance can then provide a way of meeting that tax charge and allowing the value of the business to be passed on without having to sell to create value or take on debt in some way to realize that. So in that circumstance, it works really well. Whenever we say, is it worth it, is that, well, it's to what extent you're willing to cover a liability, but it's that if any, certainly for our business owner clients, it's something we think that should be considered as part of these changes that are coming through. At the very least, can get a quote to see what it would cost, and then you can make the decision on whether it's worth it. At risk of ending on an even more morbid topic than IHT in general, is that you can sometimes be what's called rated. So if you've got certain medical conditions, the premium for you could be higher. And so some people then take the view to say, well, is this really worth it? That unfortunately, it means that an insurance company's assess you're at higher risk of this coming into payment, so that as the premium goes up, then hopefully should the value of insurance, if that's being provided. I'm not saying that applies to everybody, but it's just something to keep in mind. That certainly with more tax being payable on death and with the availability of incomes to meet the premiums, that insurance is a good option in a lot of cases.
Thank you, James, and thank you, Paul, for catching that last-minute question. We're a good team, aren't we? So I'll finish my finishing up. Where was I? So it was just to say, other than the thank yous to you for joining us and for James and Paul for everything they've inputted during this discussion. It's just to say, if you'd like any further details on anything that we've talked about, please just get in touch with your usual contact, or you can get in touch with us on our website. A recording of this will be made available on our website, and a copy will be sent to everyone who's signed up. And you're welcome to share this with your colleagues if you'd like to. You'll also have the opportunity to sign up to our last post-budget webinar, where we'll go into more detail on the changes to the non-dom rules, and you'll have a bit more time with Paul talking those through. So that's one not to be missed. Thank you for joining us today, and I hope you have a lovely afternoon. Bye.